Administrative Law Case Digests. First case. Alegre v. Collector of Customs. Facts. Petitioner is engaged in the production of abaca and its exportation to foreign markets. He applied to the respondent for a permit to export 100 bales of abaca to England, but was denied. He was advised by the respondent that he would not be permitted to export the abaca in question without a certificate from the Fiber Standardization Board. So he filed a petition for a writ of mandamus, alleging that the provisions of the Administrative Code for the grading, inspection and certification of fibers, in particular, Sections 1772 and 1244 of that code, are unconstitutional and void. Issue: whether or not the authority vested in the Fiber Standardization Board is a delegation of legislative power. Held, no. The legislature has enacted a law which provides for the inspection, grading and baling of hemp before they can be exported to other countries and the creation of a board for that purpose, vesting it with the power and authority to do the actual work. Such authority is not a delegation of legislative power and is nothing more than a delegation of administrative power in the Fiber Board to carry out the purpose and intent of the law. In the very nature of things, the legislature could not inspect, grade and bale the hemp, and from necessity, the power to do that would have to be vested in a board or commission. The petitioner's contention would leave the law, which provides for the inspection, grading and baling of hemp, without any means of its enforcement. If the law cannot be enforced by such a board or commission, how and by whom could it be enforced? The criticism that there is partiality or even fraud in the administration of the law is not an argument against its constitutionality. Second case. Calalang v. Williams. Facts. The National Traffic Commission, in its resolution of July 17, 1940, resolved to recommend to the Director of Public Works and to the Secretary of Public Works and Communications that animal-drawn vehicles be prohibited from passing along Rosario Street extending from Plaza Calderón de la Barca to Dasmariñas Street, from 7:30 a.m. to 12:30 p.m. and from 1:30 p.m. to 5:30 p.m., and along Rizal Avenue extending from the railroad crossing at Antipolo Street to Ekeg Street, from 7 a.m. to 11 p.m. from a period of 1 year from the date of the opening of the Colganti Bridge to traffic. The chairman of the National Traffic Commission, on July 18, 1940, recommended to the Director of Public Works the adoption of the measure proposed in the resolution, in pursuance of the provisions of Commonwealth Act 548, which authorizes said Director of Public Works, with the approval of the Secretary of Public Works and Communications, to promulgate rules and regulations to regulate and control the use of and traffic on national roads. On August 2, 1940, the Director of Public Works, in his first endorsement to the Secretary of Public Works and Communications, recommended to the latter the approval of the recommendation made by the Chairman of the National Traffic Commission, with the modification that the closing of Rizal Avenue to traffic to animal-drawn vehicles be limited to the portion thereof extending from the railroad crossing at Antipolo Street to Azcaraca Street. On August 10, 1940, the Secretary of Public Works and Communications, in his second endorsement addressed to the Director of Public Works, approved the recommendation of the latter that Rosario Street and Rizal Avenue be closed to traffic of animal-drawn vehicles, between the points and during the hours as indicated, for a period of 1 year from the date of the opening of the Colganti Bridge to traffic. The Mayor of Manila and the Acting Chief of Police of Manila have enforced and caused to be enforced the rules and regulations thus adopted. Maximo Calalang, in his capacity as a private citizen and as a taxpayer of Manila, brought before the Supreme Court the petition for a writ of prohibition against A. D. Williams, as chairman of the National Traffic Commission, Vicente Ferganti, as Director of Public Works, Sergio Bayan, as Acting Secretary of Public Works and Communications, Eulogio Rodriguez, as Mayor of the City of Manila, and Juan Dominguez, as Acting Chief of Police of Manila. Issues: whether or not there is an undue delegation of legislative power. Ruling: there is no undue delegation of legislative power. Commonwealth Act 548 does not confer legislative powers to the Director of Public Works. The authority conferred upon them and under which they promulgated the rules and regulations now complained of is not to determine what public policy demands, but merely to carry out the legislative policy laid down by the National Assembly in said act, to wit, to promote safe transit upon and avoid obstructions on roads and streets designated as national roads by acts of the National Assembly, or by executive orders of the President of the Philippines, and to close them temporarily to any or all classes of traffic whenever the condition of the road or the traffic makes such action necessary or advisable in the public convenience and interest. The delegated power, if at all, therefore, is not the determination of what the law shall be, but merely the ascertainment of the facts and circumstances upon which the application of said law is to be predicated. To promulgate rules and regulations on the use of national roads and to determine when and how long a national road should be closed to traffic, in view of the condition of the road or the traffic therein and the requirements of public convenience and interest, is an administrative function which cannot be directly discharged by the National Assembly. It must depend on the discretion of some other government official to who is confided the duty of determining whether the proper occasion exists for executing the law. But it cannot be said that the exercise of such discretion is the making of the law. Third case. Domingno v. Teoxin versus members of the Board of Administrators, Philippine Veterans Administration. Facts. The petitioner sustained physical injuries in line of duty as a former member of a recognized guerrilla organization which participated actively in the resistance movement against the enemy, and as a result of which petitioner suffered a permanent physical disability. For having been permanently incapacitated from work, he filed his claim for disability pension with the Philippine Veterans Administration under the Veterans Bill of Rights, Republic Act No. 65. However, respondents in turn would limit the amount of pension received by him in accordance with the rules and regulations promulgated by them. Petitioner filed his suit for mandamus before the CFI of Manila alleging that he filed his claim for disability pension under the Veterans Bill of Rights, Republic Act No. 65, for having been permanently incapacitated from work and that he was first awarded only P25.00 monthly, thereafter increased to P50.00 a month. EH 405 page 17 Administrative Law Case Digests, contrary to the terms of the Basic Law as thereafter amended. 3. His claim, therefore, was for a pension effective May 10, 1955 at the rate of P50.00 a month up to June 21, 1957 and at the rate of P100.00 a month, plus P10.00 a month, for each of his unmarried minor children below 18 years of age from June 22, 1957 up to June 30, 1963, and the difference of P50.00 a month, plus P10.00 a month, for each of his 4 unmarried minor children below 18 years of age from July 1, 1963. He would likewise seek for the payment of moral and exemplary damages as well as attorney's fees. Respondent, while admitting, with qualification, the facts as alleged in the petition, would rely primarily in its special and affirmative defenses on petitioner not having exhausted its administrative remedies and his suit being in effect one against the government, which cannot prosper without its consent. The CFI found for respondents. Hence this petition. Issue: whether or not rules and regulations promulgated by administrative agencies can prevail over a statute. Held. Petition is affirmed. CFI is reversed. The court cited the case of Bigosa v. Chairman, Philippine Veterans Administration, promulgated just a month before the case at bar, where it categorically held that a veteran suffering from permanent disability is not to be denied what has been granted him specifically by a legislative enactment, which certainly is superior to any regulation that may be promulgated by the Philippine Veterans Administration, presumably in the implementation thereof. It added that the decision of the CFI where it held that the respondent board has authority under the pension law to process applications for pension, using as guide the rules and regulations that it adopted under the law and their decisions, unless shown clearly to be in error or against the law or against the general policy of the board, should be maintained is clearly erroneous. The court also cited United States v. Potpourri Molina, which held that of course the regulations adopted under legislative authority by a particular department must be in harmony with the provisions of the law, and for the sole purpose of carrying into effect its general provisions. By such regulations, of course, the law itself cannot be extended. So long, however, as the regulations relate solely to carrying into effect the provisions of the law, they are valid. As well as its ruling in People v. Santos, wherein it held that an administrative order betrays inconsistency or repugnancy to the provisions of the Act, the mandate of the Act must prevail and must be followed. Finally, the court said there must be strict compliance with the legislative enactment. Its terms must be followed. The statute requires adherence to, not departure from, its provisions. No deviation is allowable. In the terse language of the present Chief Justice, an administrative agency cannot amend an act of Congress. Respondents can be sustained, therefore, only if it could be shown that the rules and regulations promulgated by them were in accordance with what the Veterans Bill of Rights provides. Fourth case. Lupanko v. Court of Appeals. Facts. PRC issued Resolution No. 105 as parts of its additional instructions to examinees, to all those applying for admission to take the licensure examinations in accountancy. Petitioners, all reviewees preparing to take the licensure examinations in accountancy, filed with the RDC a complaint for injunction with a prayer with the issuance of a writ of a preliminary injunction against respondent PRC to restrain the latter from enforcing the above-mentioned resolution and to declare the same unconstitutional. Issue. Can the Professional Regulation Commission lawfully prohibit the examinees from attending review classes, receiving handout materials, tips, or the like 3 days before the date of the examination? Rule. We realize that the questioned resolution was adopted for a commendable purpose, which is to preserve the integrity and purity of the licensure examinations. However, its good aim cannot be a cloak to conceal its constitutional infirmities. On its face, it can be readily seen that it is unreasonable in that an examinee cannot even attend any review class, briefing, conference or the like, or receive any handout, review material, or any tip from any school, college or university, or any review center or the like, or any reviewer, lecturer, instructor, official or employee of any of the aforementioned or similar institutions. The unreasonableness is more obvious in that one who is caught committing the prohibited acts even without any ill motives will be barred from taking future examinations conducted by the respondent PRC. Furthermore, it is inconceivable how the Commission can manage to have a watchful eye on each and every examinee during the 3 days before the examination period. It is an axiom in administrative law that administrative authorities should not act arbitrarily and capriciously in the issuance of rules and regulations. To be valid, such rules and regulations must be reasonable and fairly adapted to the end in view. If shown to bear no reasonable relation to the purposes for which they are authorized to be issued, then they must be held to be invalid. Resolution number 105 is not only unreasonable and arbitrary, it also infringes on the examinee's right to liberty guaranteed by the Constitution. Respondent PRC has no authority to dictate on the reviewees as to how they should prepare themselves for the licensure examinations. They cannot be restrained from taking all the lawful steps needed to assure the fulfillment of their ambition to become public accountants. They have every right to make use of their faculties in attaining success in their endeavors.